Hello, this is estate planning attorney and fiduciary investment advisor Jeff Fouts here. We are a firm that specializes in estate planning, and everything we do is geared around helping you achieve several goals. Firstly, is to make everything faster, cheaper, easier after you become incapacitated or die, with less taxes, court, and attorney involvement. And then after you die, we can protect your spouse's inheritance from going to your next spouse and protect your children and grandchildren from losing their inheritance due to divorce, lawsuits, and predators. We want to use our 32 years of specialized experience to help you have peace of mind and not worry. Our philosophy of estate planning is that you should be as bulletproof as you possibly can, and that's why we talk about these important things. Now, today, I'm going to talk about part one of 7 different ways you can leave your assets to your children or heirs. So there's lots of different ways to leave things to your heirs, and we're going to look at the 7 different ways you can leave them. Now, today I'm going to be covering the first of the 7 ways. The first way isn't about necessarily to leave it to your children or heirs after you die, but it's about giving it to them while you're still alive, and that's called a lifetime gift. The other 6 ways I'll be discussing in future videos will be about how to leave it to your children or heirs at your death. Now, a lot of people make lifetime gifts to their children. Giving gifts to your children, grandchildren, or other heirs during your lifetime can be done using one of 2 different ways. The first way is what is called an outright gift. When you make a gift outright, you're simply writing a check, in other words, to the person for some amount of money, or you're giving them a piece of real estate and you're deeding that property to them. You're putting it in their name and it's all theirs with no strings attached whatsoever. The second way to give something to a child or to an heir during your lifetime is to put that gift in a trust. And this is where you create a document that says something like, I'm giving you this $20,000, but you don't get it all at once, all at this time. You don't have full control of it today. You're going to get it according to the terms of the trust. And so there are many options. Now remember, that trust is set up while you're alive for money to go to that heir while you're alive. So we're not talking about after your death using this methodology. Sometimes people want to set up a trust where you can make a gift or gifts in trust for your children so they'll have funds for college. You can make it so that they can only get it for education if you want, and then they get full control or of any remaining amount when they turn 25 or whatever age you specify. And so there are many different ways you can design a trust. Today I'm going to focus on the method of giving where you don't put it in a trust, where you give money or an asset away outright with no strings attached, not in a trust. So let's answer the question, why do people make gifts during their lifetime? Well, many people make outright gifts during their lifetime, and they make them usually to their children or grandchildren, and there are different reasons people make these gifts. And one is because they want the child to get they want to get those assets out of their estate for estate tax purposes. But other people make outright gifts, not necessarily to benefit themselves for a tax reason, but because they want to help their child or heir. And for example, they want to help a child get through a life event. Maybe the child is going through a divorce and they need money to pay their attorney's fees and get their life back on track. Or maybe you give a child money for a down payment on a house. So people make gifts while they're alive, either outright or in trust, because they want to help those children or grandchildren, and because they want to see the descendant benefit from the gift. See, that's an advantage of giving while you're alive. You get to see them benefit from it. Okay. Now, some people gift assets because they want to get assets out of their name for probate purposes. Sometimes folks put their house in a kid's name. But that, to my mind, is a very bad move that has many dangers and negatives. And so I want to talk about some of the negative consequences of gifting. There are several negative consequences that you really need to be aware of before you make a gift during your lifetime to children, grandchildren, or heirs. So one negative consequence, if you give an asset away, is you lose control over it. You can't get it back. You can't write a check to someone for $40,000 and then later say, hey, we're in a financial bind now. We need you to give that $40,000 back. Well, they don't have to give it back to you. They may give it back, or they may not. But also, they may have already spent the money. They may already blowed it or spent it on something. And so when you give up both ownership and control when you make an outright gift during your lifetime. Also, if you put an asset in an irrevocable trust for the benefit of your child or grandchildren, you lose control of it then as well. The second negative consequence is a negative tax consequence if you give away an appreciated asset. An appreciated asset means it's an asset that has grown in value since the date you got it. All right, the people you give it to are not going to benefit from what's called the step up in cost basis. That's an IRS rule that they would normally have benefited from if they had inherited it from you when you died. So let me give you an example. Let's say that you have a piece of property that you purchased 20 years ago for $10,000, and now it's worth $100,000. Now that example may not be realistic, but it's just an example. You give it to your son while you're alive. Your son gets what's called a carryover basis from the lifetime gift. Okay, they do not get the step up in cost basis. Your basis was $10,000. You give that $100,000 piece of property to your son, and your son's cost basis is now the same as yours was, which is $10,000. That means that when your son sells the property in the future, since there's been a lot of appreciation, all that appreciation will be taxed at capital gains tax rates. So there's going to be thousands of dollars in capital gains. Now let me compare that scenario with the scenario where instead of giving it to your son while you're alive, you kept it and your son inherited it from you at your death. And in this instance, the child would have benefited from the step up in cost basis. The child's cost basis, if they inherited it from you when you die, would be the fair market value of the property at the time of your death, or the $100,000. Then, when the child sells it, there would be little or no capital gains tax on it at all. If they sold it for $100,000, there's no capital gains at all. If they sold it for something above $100,000, they would only pay the capital gains on the difference between the 100 and the whatever it is, $130,000. So if you make a gift to someone during your lifetime, so now let's talk about gifting. Okay, this is a different scenario. If you make a gift to someone during your lifetime in excess of $19,000, and that's the gift tax exclusion for the year 2025, you have to file an IRS Form 709 gift tax return by April 15th of the year after you made the gift. So it's a separate tax return that's not part of your normal 1040 income tax return. You have to report that you made a gift in excess of the $19,000, but you won't owe any tax. Okay? So let's talk about negative consequence number 3. If you give away your home, for example, during your lifetime, you are going to experience another negative consequence. And so let's say that you put your home into your children's names, but you still live there. Everybody understands that you're going to live there for the rest of your life. So why did you do that? Well, maybe you did it because you don't want your children to have to go through probate after you die. Putting your home in your children's name makes your children the owner. So now you're not going to qualify for any tax exemptions, school tax exemptions. They're gone. The annual property tax bill is going to go up, probably way up, and that's not a good thing. The fourth negative consequence is that if your home has been transferred into your children's name and you or your child want or need to sell the house, you lose a very valuable tax benefits. Now, if you had left the property in your name, you could have sold it and you would have got a tax exemption on the first $250,000 if you're single, or $500,000 if you're married, of gains, which means you'd probably have to pay, if you'd kept it, you'd not probably had to pay any or little tax, but now you're probably going to have to pay a good bit of capital gains tax. So the opportunity to get that exemption from the capital gains tax is now gone. It's eliminated because you gave your house to your children during your life. Now they own the home, you don't. Even though you may live in the house, it's not your home anymore. So if that home is sold during your lifetime, the children are going to have to pay tax on that gain. That $250,000 or $500,000 exemption from capital gains is gone, all because you gave the home away during your lifetime rather than at your death. So, in summary, it's important, very important, if you are considering making a lifetime gift, to ask, why am I making this gift? What am I attempting to achieve? Now, perhaps the benefit to you and the benefit to your family more than outweighs any negatives, but sometimes it doesn't. And sometimes making the gift makes sense, but sometimes it really doesn't make sense. And some of the some of the other issues haven't been considered or fully understood. So you need to understand all of these consequences and all of these things surrounding making lifetime gifts. So this is part 1 of 7 on how to leave it to the kids. And this one is about lifetime gifts, either outright or in trust, mainly outright we've been talking about. Videos 2 through 7 are all about how to leave it to kids or heirs when you pass away. Now, as I said, believe it or not, there's 7 different ways to do this, and I'm going to have a video on each way, so stay tuned. I'm Jeff Fouts, so have a good day. Now, as I said, we are a law firm that specializes in estate planning. Everything we do is geared around educating you as to what all your options are, including options you've never thought about, like IRA Retirement Protection Trusts. You've worked hard for decades to build up what you have. Assets take a long time to accumulate, but they can go very, very quickly. For 32 years, we've helped protect assets against spousal remarriage, children's divorce, lawsuits, irresponsibility, and taxes. And so I encourage you to go to our website at foutsestatelaw.com, foutsestatelaw.com. You can attend our upcoming live workshops or our virtual seminars. And more importantly, you can visit with us personally by calling and setting an appointment. There's no cost, no obligation, no commitment at all, ever, and we will always part friends. So I hope you have a good day. Thank you.